The statute itself is very clear about who can bring a lawsuit. It says that a gambler can sue to recover his own gambling losses within 90 days. If he doesn't do that, then any other person can sue to recover the gambler's losses for the use of his spouse, children, or next of kin. Mr. Braden is any other person. He has alleged and is not disputed that he never gambled at this online casino. Nevertheless, the trial court said that he did not have constitutional standing because he didn't have an injury in fact. And we respectfully think that's an error. Our authority for this begins with Fannin versus City of La Follette, a Tennessee Supreme Court case from 2010. In that case, the plaintiff was challenging a city council for operating in secret. The Supreme Court found that the plaintiff did not have an injury in fact. Also, the plaintiff did not have standing under the taxpayer standing rules, which are also common law rules. Nevertheless, the Open Meetings Act said that any citizen of this state can sue for a violation of the act, and therefore the plaintiff had standing. So this is an example of a case where the plaintiff had no injury in fact, but nevertheless had standing just because a statute said so.
How is there an injury to Mr. Braden's legal rights in this case? And so, in looking at cases like Wilmington and thinking about Fannin, legal rights injury cases, there's still an injury to the legal right of the person. How were his legal rights injured here?
Well, I think the case versus Wilmington analysis, we've made that argument. I think it's separate. So just to be clear, and I'm going to answer Your Honor's question, I think the statute just solves the question of standing, but if you look at case versus Wilmington, I think what it means by injury in law is just that the law says you have an injury. I think of that example.
So could the legislature pass a statute that said the Harm to Others Act, where you have a right to bring an action where there's some sort of harm to any legal right to another person, and there would be standing consistent with the Tennessee Constitution?
Well, the legislature has enacted laws like that. So one example I would contend is the wrongful death statute. It says that the surviving spouse has the right to bring the cause of action and is in total control of the case. Nevertheless, it's an action that will benefit other third parties, such as the children of the deceased.
Aren't we pretty far afield from that, though, when you're talking about a circumstance of a totally unconnected person? I mean, this isn't falling in some sort of historical line of next friend cases, and this is seems like a significant step beyond that.
The way to classify this is as a qui tam or informer statute, and as we've shown in our reply brief, there's a long history of these statutes in Tennessee and elsewhere.
But qui tam and if we look back at the Vermont agency case, right, that's the concept there is it's an assignment of somebody else's right in which the qui tam plaintiff, person bringing the suit, has a financial interest in the recovery. Here, Mr. Braden, under the language of, the statutory provision here, it's to recover for the spouse, the child, and next of kin. So it seems to me that it's different. I mean, qui tam's already sort of pushing on the outer edges of standing in a lot of ways, but here, there's not even a bounty provision for it. It's a return to the family provision.
Right, and it's true, Mr. Braden does not have a financial incentive to bring the lawsuit. The money does not go to him. However, what it comes down to is that the legislature has deemed him injured enough to go to court. And the question then is, does the legislature have that power? And we contend that it does, because all of the cases we found have said that it is within the power of the legislature to create a cause of action, to determine what the remedy is, and to say who can bring the cause of action. And so a court would have to override what the legislature said in that case to take standing away from the plaintiff. And we think that that is not what we're supposed to do, because that creates a separation of powers issue. And separation of powers, of course, is one of the two constitutional pillars of standing law. In this case, the legislature has made a policy decision. It's spoken about standing. And so we think that that decision has to be honored.
These types of statutes are not necessarily rare. They have historical existence. Are you aware of any case in Tennessee? I know you cite the Kentucky case. As I recall, though, that's the Kentucky government that brought that action. That's not a private party case, right?
The Commonwealth of Kentucky.
Commonwealth of Kentucky brought that.
Although I would add, just to finish my answer, that The Kentucky Supreme Court did not base its decision on that fact. That is true, but it just said it's any other person.
Are you aware of any case in Tennessee, in any other jurisdiction, where a gambling provision such as this has been utilized in the way that you're utilizing by a private citizen rather than by a governmental entity?
I'm not aware of a case in Tennessee, and I'd have to think, but I don't think I'm aware of one in another jurisdiction where a non-governmental plaintiff brought the lawsuit successfully under the third-party provision of the Loss Recovery Act. I would say that it's rare for this to even come up because, at least under Tennessee statute, the money goes to the families, so there's really no financial incentive for third parties to do it, but that doesn't change what the statute says. It says any other person. And so that's what I think we have to come back to, is that this is a policy decision, and that is within the power of the legislature to decide who can bring the cause of action that the legislature itself created. And so I think that the proper way to analyze this under Fannin versus City of Lafayette, as well as this court's decision in Sons of Confederate Veterans versus City of Memphis, which was a similar ruling, that even a party that does not have an injury in fact is entitled to sue if a statute says so. So I think that's clearly the decision in Fannin as well as Sons of Confederate Veterans. In the Sons of Confederate Veterans case, the Historical Preservation Society challenged the removal of a Confederate statue. This court said that the plaintiff did not have an economic injury, did not have even an aesthetic injury, so there wouldn't have been an injury in fact, but nevertheless it could sue because the statute said so.
Turn back to Wilmington, the language that the Supreme Court stated, they still must have an injury. That is, at minimum, they must have an injury in law to access the courts. So back to that very first question, what is the injury in law to Mr. Braden in this case? How did he have, I mean, the example the court utilizes, right, for injury in law is trespass. There's no real damage done, but you enter onto the property. It's an injury in law to my legal right to prevent you from coming onto my property, even though there's no actual damage. That seems far afield from what we're looking at here.
I'm not sure it is. I mean, if in that classic hypothetical of someone shooting the bullet over the neighbor's yard and the bullet doesn't hit anything or damage anything, but the law deems the landowner to be injured so that he can go into court, why can he do that? It's only because the law says he can do that. He hasn't suffered anything. It's just a dignitary harm or something that the law, it's a legal fiction essentially. So,
but shouldn't we want the person that lost the 1999 to be the person to bring this recovery? I mean, shouldn't the law direct us there?
well, that's great, and certainly that person can do it within 90 days. But if that person doesn't do it within the 90 days, then the state has made, I think, a policy decision that it's important enough to enforce these gambling laws that we're going to open it up to other people to bring the suit. So we're not trying to preclude any gambler from recovering. We're not aware of anyone trying to do that. And in fact, our complaint says if a gambler has done that, that person is excluded. We're not trying to overlap.
But you're also taking away the rights from the spouse or the child
Next of kin.
or the next of kin to do it.
I don't think we're taking away anyone's rights.
Aren't you raising a claim on behalf of every single person who has lost or has had money in this gambling website?
Well, I think realistically, I mean, none of those people are going to get anything unless the statute can be utilized this way, because nobody can bring an individual lawsuit for $500 or something like that against a company. So really, they're not going to get anything, and they haven't tried precisely, I think, because of what I just said. So to the contrary, we're not taking away anything from anybody. We're the only people trying to recover the gambling losses and give those to the family. Could they have done that? Sure. Any other person can do it. That's what the statute says.
Was there a statute passed that allowed gambling online in Tennessee?
Sports gambling.
Okay.
So specific exceptions.
So if there are statutes that allow it, do they override this statute?
Well, no statute allows this kind of gambling. So a statute allows sports gambling under very specific regulations. Mm-hmm. People have to get licensed. They're subject to a bunch of regulations, pay fees to the state. These companies are doing it with zero regulation. So it's just a different area. And the fact that the state has specifically allowed those other types of gambling, but not this type, I think indicates clearly that it's not wanted by the legislature.
Okay.
I do want to, if I may, say that I think the Case versus Wilmington analysis is separate from the statutory standing analysis. And we know that because in Case versus Wilmington, it cites back to the Fannin case. And it classifies Fannin as a public rights case. So if that case were subject to the private rights, public rights analysis, then that plaintiff would have needed to show an injury in fact to sue, because that's what Case versus Wilmington says. But we know that that was not the holding of Fannin. In that public rights case, that plaintiff had no injury in fact, but still had standing just because the Open Meetings Act said any citizen of the state can sue. And we think that that is the controlling decision for this case, because we have a statute. Case versus Wilmington was a common law case.
In Fannin, though, there's an injury to the ability of that person. If Open Meetings Act, I was not able to attend the meeting because the meeting was not properly made a public meeting, and that seems different than a circumstance where we're here. I'm still struggling to figure out what the injury at law is for the party in this case.
Well, I would just point out that in Fannin, the court didn't say that plaintiff was harmed in any way. In fact, the court went through it in very fine detail and said there is no injury to that particular plaintiff, either as a legislator or in any other way. So the end result of that, I think very clearly, is a person who has no injury at all may have standing just because of a statute, and I think that's what we have here. I don't have much time, but I just want to briefly allude to the second issue in the appeal, which is the scope of the case. This is a very important issue because, as I said, if people had to bring hundreds of claims for $100 against a company, that's not going to happen. That's not able to be done. So I can maybe talk more about this in rebuttal, but we believe that was an error, that the way the statute is written, and as the Kentucky Supreme Court held in the Commonwealth versus Stars Interactive case, a plaintiff like Mr. Braden can indeed recover the gambling losses of all the gamblers in one suit. Thank you.
Thank you very much.
Good afternoon. May it please the court, my name is John Nyman. I'm admitted pro hac vice from the State Bar of Alabama. I'm grateful for the privilege of representing the defendant and appellee in this case, ARB Gaming LLC, which respectfully ask this court to affirm the very thoughtful order that the trial judge initially delivered from the bench during the hearing in this case and ultimately memorialized in a written order. The introductory colloquy between my friend and Judge Usman anticipated the way I wanted to start, which is to say that the Tennessee Act at issue here closely resembles laws that are on the books in as many as 30 states, as far as I can tell. Those laws have been around for hundreds of years. They're premised on, or they're based on, an old English statute, yet not one reported decision of which I'm aware has ever allowed an individual like Mr. Braden, who claims no loss of his own, to utilize one of the statutes in this way, where he'd effectively appoint himself a private attorney general and seek money for the use of thousands of people across the state of Tennessee whom he doesn't purport to have any kind of relationship with. As the trial judge recognized, established principles of standing preclude that result. Now, just to be clear, in response to my friend's comments on the ultimate merits here, the facts relating to the ultimate merits of his claim, i.e. is this gambling, are disputed here, and hotly so. But the facts relating to his lack of standing are not. He concedes, he admits that he's never played these games. He's suing for what he himself calls moral and social reasons, and so he can personally, in his words, enforce Tennessee's anti-gambling laws.
Under 2919-105, any other person is extraordinarily expansive, and isn't it designed to allow, as it says, any other person to come in and essentially act to the aid of a spouse, of a child, of a person whose loved one is losing, and I understand you dispute that it's gambling, but has lost funds allegedly through gaming activities. And isn't the statute authorizing exactly this type of action? A do-gooder that sets out to right the wrongs of gambling losses.
No, Your Honor, respectfully, it is not. And there are, I guess, two reasons why. And the first reason is a dodge of the question, which is to say, regardless of what the statute purports to authorize, constitutional standing is constitutional. It enforces the separation of powers between the executive branch and the legislative branch. So even if the legislature had intended to authorize this kind of action, it couldn't do so under the constitutional standing doctrine. Second, though, the statute, by its terms, does not authorize an action of this sort brought by someone who has no relationship with either the purported gambler or the family of that person, and who seeks...
Something that the constitutional avoidance principles in terms of statutory interpretation, is this a place where that canon would come into play in terms of thinking about how we should read the language of 105?
Yes, Your Honor. So there are a couple of reasons why, even if we could get past the constitutional standing issues in this case and interpret the statute in a way that avoids them, it would not lead to the result that my friend Mr. Wall wants to achieve here. One is that the text of the statute at every juncture screams out the premise that at the very least the plaintiff will be able to name the particular person who he's seeking recovery for, and can't just say, I'm pursuing recovery for thousands of people who I refuse to name and I don't know. The reason is that the statute refers to the loser and the family whom would benefit, for whose use the money would be spent, just as a plaintiff would be expected to name themselves and be expected to name, put in their complaint the identity of the defendant. The statute presupposes that the plaintiff is going to name the family member and the person who is alleged to be the gambler.
Does that lead? Oh, sorry.
Go ahead. No, go ahead.
Does that lead to a different result for the named, where we do have a named person in this case who says, I lost this much money? Is this one where we distinguish and maybe the result looks different for the named person versus the whole rest of the non-class here?
No, for the second reason why I'd say the statute should be read in a way that avoids the constitutional problem. The guiding precedent I'd suggest for this point is the Tennessee Supreme Court's 2006 decision in the Holton case, which construed similar language. Let me say, it endorsed the U.S. Supreme Court's construction in the Whitmire versus Arkansas case of similar language in the federal habeas statute. That statute allows for another person besides the real party in interest to file a federal habeas petition on behalf of the prisoner. The court there said that according to, as Your Honor suggested earlier, next friend type principles, the plaintiff in those cases, this other person in those cases, has to satisfy two statutory standing type requirements. One is they have to show that the real party in interest, there was some reason, and Judge McBrayer, this goes to your question, there's some reason why the real party in interest can't file the lawsuit.
Yeah, so we don't have to resort to table contiguity to figure out how closely related they are to the gambler. I mean, you're doing this sort of next friend type analysis.
That's right, and it conceivably could be someone who's not even a member of the family.
Not a next of kin, but
yes, exactly. But at the very least, they need to show that the person who originally spent the money can't bring the lawsuit on their own, and the family members can't bring the lawsuit on their own. Secondly, the Supreme Court in Whitmire and the Tennessee Supreme Court in Holton suggested that the person who brings the lawsuit also needs to be able to show that they would zealously represent the person whose interest they're seeking to vindicate. In other words, there need to be allegations in the complaint that explain why this particular individual, or why the plaintiff in this case, can be trusted to adequately represent the named person in the complaint. We have no allegations like that at all in this complaint, even though the plaintiff would have had ample opportunity to explain why he has named this particular person and why he could be trusted to zealously represent her in the proceedings in this case. So for that reason, even the naming of this particular individual doesn't save this case from dismissal. Let me say that I guess there are really three steps the court could take here in terms of affirming the court's order, or the lower court's order. One is to hold that this case involves public rights, the redress of public rights, and Mr. Braden's admitted lack of injury in fact means that the case needs to be dismissed on that grounds. The second, as Judge Usman's questions earlier suggested, would be to say that even if this case involves private rights, there's still a constitutional standing problem in the case. And the reason why I would ground, Your Honor, in the plain language of the Tennessee Open Courts provision. So in the Case versus Wilmington Trust decision, the Tennessee Supreme Court said that even in a private rights case, the Open Courts provision is doing some work. What does the Open Courts provision say? It says the courts of the state will be open to redress injury for a plaintiff done, quote unquote, to him. The problem with this case under the Open Courts provision is that, as the questions and answers earlier suggested, Mr. Braden isn't seeking redress for any injury done, quote unquote, to him. He's suing under a statute where, by his own admission, he would need to fork over any money that he obtained during the course of this litigation to someone else. He himself said, Mr. Wall said during his argument, that there's really no financial incentive for Mr. Braden to bring this lawsuit. That's one of our points exactly. The lack of financial incentive he has to bring this lawsuit is all the more reason to conclude that he's not suing for injury done to him, and thus there is an added constitutional standing problem on top of the public rights issue.
Is that the key basis for distinguishing this from, for example, a key TAM suit? Because there is no, in key TAM, your interest, I mean, you're vindicating the interest of the United States government or the state of Tennessee, but you have your own financial interest in a bounty, essentially, that's being provided for, whereas here, the legislature is not providing for a bounty. It's not, you go sue the gaming company, I know you dispute this gaming company, go sue the gaming company and you keep the money. Instead, there's no bounty. Is that the critical distinction between this and a key TAM suit?
That's one of them, Your Honor. So the existence of the bounty, and as you put it earlier, the assignment of the interest from the United States government, in the case of the federal key TAM statute, to the individual, provides the critical injury, in fact, that Mr. Braden lacks here. The other key distinction, I'd say, that is that in a key TAM case, ultimately the Attorney General of the United States on the federal level retains some authority over the case to superintend and direct the litigation. Under Mr. Braden's conception of this statute here, he's suing to vindicate and enforce Tennessee's gambling laws. He's suing for moral and social reasons, yet the Attorney General of Tennessee has no ability to come in under his conception of things and superintend the case. And that's why, a key TAM case may well not have standing problems under the public rights doctrine, but this case does because of the critical separation of powers issues that are bound up in that doctrine.
Is it fair to say that Tennessee Supreme Court has expressed some uncertainty as to where the exact line is between public and private rights in terms of their decision-making in that vein? Yes,
it's quite fair to say that, and that's the precise reason why, with apologies for the belated nature of our filing, earlier this week we filed in a 27D letter that sought to bring to the court's attention the decisions in Houghton, which I believe was decided around October of 2025, and then much more critically, I'd say, it's Wygant, the Wygant case, which was the redistricting case decided in December of 2025. I'd point the court to footnote 10 of that opinion, where the court does exactly what you just suggested, say the bounds of the public rights doctrine are a little uncertain, but here are the two components that we think appear to be present even in the discussion in Case versus Wilmington Trust. One is, admittedly, the one that Mr. Braden
I assume you would
raises.
agree that, at least in terms of one of the potential routes identified by the Tennessee Supreme Court in terms of defining the line between public and private rights, the idea of suits against the government versus suits not against the government, that would point towards this as a private rights case. Not saying that's what the law is in Tennessee, but one of the potential routes identified by the Tennessee Supreme Court would put it in that category.
Well, I disagree with the notion that that points towards this case being a private rights case. I would completely concede that that Mr. Wall is right to say that if you have a case, individual plaintiff suing the government under Case v. Wilmington and under Justice Thomas's opinion in Spokio, which seems to be the basis of the Tennessee Supreme Court's doctrine in that case, that's clearly a public rights case. What I would say, though, is that the discussion both in Justice Thomas's concurrence in Spokio, but also in Wygant footnote 10, which cites Wilmington Trust for this proposition, suggests that there's a separate type of public rights case, one that does not involve a suit by a private individual where they're suing the government. Instead, in the words of the Supreme Court in Wygant, an assertion of a right that belongs to society as a whole rather than an individual, or as Justice Thomas put it in Spokio, suits that are the government itself has the authority to pursue. That's the sort of case that we have in this case. How do we know that? Because Justice Thomas in Spokio was dealing with a federal statute that allowed a plaintiff to sue not the government, but instead a private party, a consumer reporting agency. It was a statute that created the cause of action. Justice Thomas nonetheless said that the bulk of the rights that were at issue in Spokio were public rights, not private rights. We'd suggest that, and Justice Thomas said for that reason, the standing doctrine required a showing of injury in fact. The plaintiff's case would be due to be dismissed under that doctrine. We'd submit that the same analysis would apply here. We're dealing with the sorts of cases that Justice Thomas said fall within this component of the public rights doctrine. The examples he listed in his concurrence included actions to enforce the penal laws, public nuisance actions, and actions to enforce general regulatory duties. That's the sort of thing that is going on here with respect to Mr. Braden's suit. He is seeking, in his own words, to enforce Tennessee's penal laws, Tennessee's gambling laws. He's also filing an action that looks much like a public nuisance action in the sense that he is seeking recovery for everyone in Tennessee that has played this game, not for particular individuals. That puts this case squarely within the public rights arena, and thus it makes it one in which the requirement for injury in fact should be fully imposed. I've got about 20 seconds left. Let me just say Mr. Wall has relied heavily on the Fannin versus La Follette case, the Open Meetings Act case. Review of that opinion would show that the court, in finding that there was standing to pursue an Open Meetings Act claim, did not really consider at all how the injury in fact requirement would work in that case. It's clear that that would be a public rights type case. The court says that the plaintiff in that case had established standing, but can only be understood to have held, although the court doesn't say so expressly, that the procedural injury that the plaintiff suffered there, the inability to have access to the government during critical junctures, was enough to give rise to injury in fact in that case. My time is up. I appreciate the court's time.
Thank you very much. Mr. Wall?
Thank you. The standing provision in the statute says any other person. We think that's unambiguous. It doesn't say that the person like Mr. Braden can only sue if the gambler had some obstacle that prevented him from suing. It just says that if the gambler doesn't sue within 90 days, any other person can sue. So we think when we talk about standing, another way of talking about this is the court going to rule that the legislature cannot do this? Because I do think the language is unambiguous. When we look at the Fannin case, I would just like to read a short quotation from it, if the court will allow. When a person is expressly authorized by statute or rule to bring a particular action, his or her right of action arises directly out of the statute, and he or she needs no title under the substantive law to authorize suit. The Supreme Court was quoting this court in Mayhew versus Wilder in that passage. So we think it begins and ends with the statute. However, if you do look at Case versus Wilmington and the public versus private rights analysis, the way our Supreme Court, not Justice Thomas in a concurrence or dissent, but our Supreme Court has described public rights, is that those cases, every one of them, I think, the Supreme Court said, was brought against the government and it was asking the courts to review the actions of either the legislative or executive branch. And that is why there's a special injury in fact requirement for those cases, because courts don't want to overreach and intrude on the other branches of government. This case involves only private parties, and we're not asking a court to review any other branch of government. So under that definition or description in Case versus Wilmington, I think this is a private rights case. If it's not a public rights case, and it only involves private parties and private transactions, it has to be a private rights case. There's been some discussion about due process rights and the rights of gamblers and their family members. I want to make clear, again, this lawsuit is only about gambling losses that the gamblers themselves did not sue to recover. So their causes of action have expired. And so there's no way this lawsuit could interfere with a gambler's legal rights. When it comes to the gambler's family members, they haven't sued. And for reasons I discussed earlier, they realistically cannot do that. So the only realistic way for recovery to be given to these people is for somebody like Mr. Braden to do this.
Is there any time limit placed in the action that you're bringing here? Have you defined any time parameters? And it's this time period that we're seeking between X date and Y date?
Yes, we dated it back from the filing of the original complaint. I'm going by memory, but I think the beginning of the period was in February 2023, something like that. So it may be in the amended complaint. I'm not certain, but we have defined that. So again, that does not interfere with any gambler's cause of action, and no other family member. The family members, if they wanted to, could have brought their own lawsuits, and then we wouldn't even be talking about this, but they haven't done that, and they're not going to do that because there's no way to do that for $100 or $1,000 or even $10,000 to pay for an expert, and there's no fee shifting under the statute. So we're trying to have this statute work in a way that actually benefits people. I don't think that can be turned around to say that that's violating the family's due process rights to give them a remedy. So with all that said, this is not the only statute that the legislature has passed allowing anybody or nearly anybody to sue. Just in the last 7 years, the legislature has passed 3 or so more of these statutes, and we've cited those in our reply brief. They have to do with a lot of issues, whether governments adopted a sanctuary city policy or a firearm registry or adopted UN policies. And the legislature said we want everybody or anybody or nearly anybody to be able to file this kind of lawsuit. So I think the court's ruling in this case will be cited, if there's litigation in those other statutes. Thank you very much.
Thank you very much. Thanks to all of you. Would you call the next case, please?
In re Daisy B.